Right, I'm answering questions that were sent to me after my last video where I explained to you, if you're writing a courtroom scene in the UK, the things you should not definitely do. So catch up on that video. So here's a question from Lauren Doe, 168. Thank you for sharing your experience in UK court. I do have a question. Are witnesses ever asked to identify an item or read from a text? If so, how is this handled if the solicitor doesn't approach the witness? So, before I start, let me reintroduce myself. I'm Nadine Matheson. I'm an author, former criminal lawyer, and podcast host. Practiced criminal law for, well, over 20 years. And now I write crime fiction, mysteries, thrillers. That's me. So, I explained in my last video that in UK courts, the lawyers, they stay on counsel's row. We do not move. So, we do not approach the witness. We do not approach the bench. We simply stay in our spot. So Lauren is asking, well, how do we ask a witness to identify an item or read from a text? Well, for example, I had a trial where I had 500 text messages to put to the witness. Those text messages would have been formally admitted into the trial as an exhibit. And then when I was questioning the witness and I was asking the witness to look at the test and explain what they meant by the text message, I would ask the clerk to hand the exhibit to the witness. So then I would have a copy of the text, the witness has got a copy of the text, the judge has a copy, my prosecuting counsel has a copy, jury has a copy, and I would ask the witness to identify the text message. And that's how we do it. We simply ask the court clerk to hand the exhibit over to the witness. So whether that is a physical exhibit, for example, like a knife, that would normally be in a protective case. So you wouldn't normally like hand them the actual knife exposed. It would be in a protective case, and that will be formally admitted as an exhibit, and the clerk would hand it over. And then I would say to the clerk, pass it amongst the jury so they can look at it and examine it. I always say to my baby lawyers when I'm teaching them, always give the jury something to do. It keeps them interested. Because, someone talking at you, you're listening to a lot of information and you're not an expert in that information. If you give the jury something to do, so looking at maps, looking at photographs, handling an exhibit, keeps them interesting. So Lauren, that's the answer to the question. That's how we ask witnesses to identify an item or a text without physically approaching them. Hope that helps.